Mental
Okay, so
Hygiene
what
Law,
I'm
Article
attempting to
9,
do is I'm
1.
attempting to
Qualified
find this
psychiatrist means,
and
in
then
part,
export
a
Dorothy's
physician
audio into
licensed to practice medicine in New York State who is a diplomat of the American Board of Psychiatry and Neurology. 2. When any person under the age of 18 is admitted to or is converted from one submission status to another in any hospital, written notice of such admission or conversion shall be given to the Mental Hygiene Legal Service within 3 days. The director of any hospital may receive as a voluntary patient any person in need of care and treatment who voluntarily makes written application. That is true. 4. Under certain circumstances, a director may admit a person who is 16 or 17 years old as a voluntary patient or his or her own application. True. 5. If a voluntary patient gives notice in writing to the director of patient's desire to leave the hospital, the director shall promptly release the patient, provided, however, that if there are reasonable grounds for belief that the patient may be in need of involuntary care and treatment, the director may retain patient for a period not to exceed 72 hours from the receipt of such notice. Not to exceed 72 hours from receipt of such notice. 6. Before the expiration of the period set forth in question number 5, the director must either release the patient or apply to Supreme or County Court for an order authorizing involuntary retention of such patient. Notice of such application shall be served forthwith, and if a hearing is demanded, a date for the hearing to be fixed by the court shall be at a time no later than 3 days from the date such notice has been received by the court. If it is determined by the court that the patient is mentally ill and in need of retention, court shall forthwith issue an order authorizing retention for a period not exceeding 60 days. 7. The director of a hospital may receive and retain as a patient any person alleged to be mentally ill and in need of involuntary care and treatment upon certificates of 2 examining physicians, accompanied by an application to admission of such person. Such application must have been executed within 10 days prior to such admissions. 8. The maximum period a voluntary or informal patient may be continued in such status is 12 months. 9. The director shall cause written notice of a person in voluntary admission on an application supported by medical certification to be given forthwith to the Mental Hygiene Legal Services. Again, the director gives a person's involuntary admissions on an application supported by medical certification to be given forthwith to the Mental Hygiene Legal Services. The other part of that is the director shall cause written notice of admission of such person, including the person's rights, to be given personally or by mail, not later than 5 days, excluding Sundays and holidays, to 1. The nearest relative of the person alleged to be mentally ill, other than the applicant, if there is such person known to the notice of a person in voluntary admission on an application supported by medical certification to be given forthwith to the Mental Hygiene Legal Services. Again, the director gives a person's involuntary admissions on an application supported by medical certification to be given forthwith to the Mental Hygiene Legal Services. The other part of that is the director shall cause written notice of admission of such person, including the person's rights, to be given personally or by mail, not later than 5 days, excluding Sundays and holidays, to 1. The nearest relative of the person alleged to be mentally ill, other than the applicant, if there is such person known to the director. 2. As many as 3 additional persons, if designated in writing, to such notice by person so admitted. And that's it. Okay. 10. The papers in any proceeding under Mental Hygiene Law, Article 9, which are filed with the county clerk, shall be sealed and shall be exhibited only to parties to the proceeding or someone properly interested upon order of the court. True. 11. Which, if any of the following are true, if a person who has been denied release of, or whose retention, continued retention, or transfer and continued retention has been authorized pursuant to this article, be dissatisfied with any of such order, he may, the person himself or herself or any relative or friend in his or her behalf may act to seek the revocation of said order denying the release, etc. 2. Obtain a rehearing and review of such order. 3. Obtain a rehearing and review of such order. I already just said that. 3. A jury shall be summoned and shall try questions of mental illness and need for retention, but a jury trial may be waived. Which one is this one? 4. Any such request must be made within 30 days of the original order which denied the release, continued retention, or ordered a transfer. 12. The director of any hospital maintaining adequate staff for observation, examination, care, and treatment of a person alleged to be mentally ill and approved by the commissioner to receive and retain patient pursuant to 939 may receive and retain as a patient for a period of 15 days any person or alleged to have mental illness for which immediate observation, care, and treatment is appropriate and which is likely to result in serious harm to himself or and others. That's 15 days. The hospital maintaining adequate staff for observation. That's a regular emergency room, like a regular hospital emergency room. Now, number 13, the director of any comprehensive psychiatric emergency program. If anybody lives in Suffolk County, that's what we call CPEP at Stony Brook Hospital. It's a psychiatric emergency program for people that if you think that they're mentally ill, you can have them go there. So it's different than the regular emergency room. That's what we were talking about in question number 12. Question 13 is an actual psychiatric emergency program. Okay. And this may receive and retain therein for a period not to exceed 72 hours any person alleged to have a mental illness for which immediate observation, care, and treatment in such program is appropriate and which is likely to result in serious harm to such person or others. 14. Whenever any court of inferior or a general jurisdiction is informed by verified statement that a person is apparently mentally ill and is conducting himself or herself in a manner which in a person who is not mentally ill would be deemed disorderly conduct or which is likely to result in serious harm to himself or herself, such court shall issue a warrant. 15. Which if any of the following must be true before a person must be ordered to receive assisted outpatient treatment. 1. The person is 18 years of age or older. 2. Suffering from mental illness. 3. Is unlikely to survive safely in a community without supervision based on a clinical determination. Clinical determination. And 4. Has a history of lack of compliance with treatment for mental illness that has prior to filing of a petition at least twice within 36 months been a significant factor in necessitating hospitalization in a hospital. 2. Prior to filing petition resulted in one or more acts of serious violent behavior towards self or others, or threats of or attempts at serious physical harm to self or others within the last 48 months. Is as a result of mental illness unlikely to voluntarily participate in outpatient treatment that would enable him or her to live safely in a community. 6. In view of his or her treatment history and current behavior is in need of assisted outpatient treatment in order to prevent a relapse or deterioration which would be likely to result in serious harm to the person or others. 7. Is likely to benefit from assisted outpatient treatment. 16. If after hearing all relevant evidence the court does not find by clear and convincing evidence that the subject of the petition meets for assisted outpatient treatment, the court shall dismiss the petition. 17. If after hearing all relevant evidence, the court finds that such subject of petition meets the criteria for assisted outpatient treatment, the court may order subject to receive assisted outpatient treatment for initial period not to exceed 1 year. So if they don't find that he's in need of care, it gets dismissed. If they do, it can be in care for 1 year.